Okay, and we are live
Good
with
deal.
the Friday chat with the big man
That's me.
on the Big Man Law channel. And I need to record this too.
Minor,
Record. Huh?
minor details.
Minor details. Okay. All right. So I think we're all set to go. So we're going to do some FAQs today on our Friday chats. So and we're going to talk about drug possession and how the big man defends those that have a drug possession arrest. So Joey, let's start with the first question. What is drug possession, and why is a person arrested for it? I guess.
Well, drug possession is defined under Mississippi law. If you look at a case called Hamburg v. State, I think it's from the 1970s, if I'm not mistaken. And it defines possession as exercising dominion or control over something. You have two types of possession. One, you have constructive possession. So if I have, let's say, a joint sitting in the center console of my friend Steve's car and I'm driving it, well, there's an argument that I'm constructively possessing it, but you still have to show that I exercise some dominion or control over it. And then you have actual possession where I'm walking down the street and I got a joint in my pocket. And that's the legal definitions of possession. The way most people get caught with drug possession is either they smell like weed, the olfactory senses don't work quite the same if you've been around it a lot as if you have not been around it a lot. So they get caught on that. And then the second thing is they admit to having it on them. Very rarely, unless you're talking about drug trafficking, some serious amounts of stuff, have they been watched or something like that. And if the feds are watching you, or the state's watching you, or they have an undercover agent, or maybe they have a confidential informant, something like that that kicks in, those are much more common in the much larger cases than what you see is you're just run of the mill misdemeanors or what I consider a low grade felony. A felony is always serious, but somebody that's looking at a couple of years and probably some pretrial diversion as an option versus somebody that's looking at 20 or 30 years in prison is a hell of a different thing.
Yeah, I think this is kind of a funny question, but it's listed as an FAQ from my research. What if the drugs were not mine? Can I still be charged with drug possession?
Are you possessing them? If the answer is yes, then yes. Even if you don't own them, just because you're not the owner of something doesn't mean you don't possess it. It's kind of like the reverse analysis is a felon in possession of a firearm. Well, it's not illegal for a felon to own a firearm. It's illegal for a felon to possess it. They can have a gun safe slap full of them that they never have access to, and they're well within the law. Well, the flip side here is you don't possess it, you don't own it, excuse me, but you actually possess it. It's in your hands. So it's illegal to own a controlled substance. If you read our statute, it's illegal to possess it.
So, what are the some of the common defenses for a drug possession charge?
The first thing I always start with any criminal case, doesn't matter if it's a speeding ticket all the way up to a murder case. I'm looking at probable cause. Do they have probable cause to stop my client? If they lack the probable cause, the rest of the case dies. I just tried a case 2 weeks ago, and the judge issued an order yesterday or day before yesterday, said he did not believe the probable cause officer. So if you win on probable cause, the rest dies. In that case I just told you about, he wrote very specifically in there, I believe the DUI officer, I just don't believe the probable cause officer, and therefore the rest of it dies. Same thing applies in a drug case. You're going to look at the probable cause. They have a reason to pull that person over. If they have a reason to walk up to that person and perform a search on them. You can't just stop somebody on the street and search them because, hey, you look like a big man, so I'm going to search you. And that's the only no, that's not how it works. You got to have a reason to stop, a lawful reason at that. So the first step is the probable cause. You always go through that. And if you have somebody that didn't admit to it, admission is just a terrible thing. I don't know why people admit to police. I know why fundamentally they think, oh, I'm going to talk my way out of this, or I'm going to give an inch to prevent them from taking a mile. What you don't realize is you're given an inch of the mile they're going to take. So don't talk to them. And from there, it becomes a chain of custody. They track it to the police department's inventory. They track it down to the forensics laboratory. The main one used is here in Pearl, Mississippi. I say here in Pearl, Pearl's just adjacent to Jackson where we're at. So they take it right down the road there. And the crime lab is so backed up. It's my understanding they're not even testing misdemeanor marijuana anymore. It used to take them 12, 18 months to get one of those to come around. Even on their felony cases, it's taken a better part of a year in a lot of the cases. So then we're going to look at the forensics laboratory and their test. One, what was their methods and procedures that they used? They followed them all correctly. After that, are they going to be able to produce the person that performed the test or that person's supervisor? If you look at a U.S. Supreme Court case, Bull Cummings v. New Mexico, they held that that person now becomes your accuser under the Sixth Amendment. You have a right to confront your accusers. So they've got to bring the person that did the test or their supervisor down there. And if they can't provide that, well, the drugs go away. So there's all kind of things that I'm looking at to click away whether or not somebody did or did not actually possess drugs.
So how does unlawful search and seizure work as a defense?
If you're saying if they just busted up in somebody's house without a search warrant or something like that, and they seized it, well, then they didn't have the not probable cause. They didn't have a proper search warrant. If you don't have a search warrant, you can't just go busting up in people's houses. That little thing called the Constitution keeps getting in a lot of police officers' ways. Bad police officers. Good police officers go and do their homework. They follow the procedures, and they make it very difficult. Now, again, going back to if they just stop me on the street just because I'm walking around singing a tune, and they go, "Well, I'm gonna search this guy." No, that's not it. In fact, here in Mississippi, we have open carry, so I could be walking around with a 45 on my hip, and you still can't stop and search me. You got to have a reasonable belief that I'm committing a crime. If you don't have that reasonable belief that I'm committing a crime, you don't get to search me. And because of that, if you do search me, anything you find on me is what is considered fruit of the poisonous tree and excluded.
What is the lack of knowledge defense in drug possession cases?
That goes back to the constructive versus actual possession. I believe that's what you're asking. If I'm incorrect, let me know. Because if you didn't know that, for example, I'm driving Steve's car and there is a joint in the center console, I had no knowledge that it was there, then I did not possess it. Again, we're in the constructive possession, but even for constructive possession, case law holds that proximity is not enough. There must be some exercise of dominion or control. You have to see that I'm actually doing something with it, that I've touched it, that I've grabbed it. A good one is, say there's a brick of weed somewhere in the car, and somebody says, "Well, I didn't know it was there." One of the first questions I'm going to ask a client is, are they going to find your fingerprints on it? Because if they find your fingerprints on it, there's a pretty good chance, and it's a pretty good argument, that you exercised dominion and control over that particular object, and you knew it was there. So that's generally what I'm looking at for those kind of cases.
Yeah, that's good to know. I'm checking the chat, by the way, on the live stream to see what's there, and I'll let you know if anybody has any questions. But Charlie says, "I'm taking a break from a busy day at work to catch the big man live. You've got a lot of potential with this channel. So few of the court channels are run by attorneys with entertaining personalities." Okay, Charlie's got a question here. Good one, Charlie. Have you ever had clients get charged for possession of CBD where it had to be sent to the lab to see if it was CBD or marijuana?
So what we run into here is the hemp, the Delta 8 and all that. And there's specific statutes on Delta 9, Delta 10. But for example, Delta 8's not mentioned. If I got a client that's got Delta 8, I've gone into the courts and made the argument that, hey, it's one molecule off. So Delta 8 gets treated just like all the other ones. And if the crime lab can't show the percentage, and I'd have to go back and look at those statutes because it's a very low number, like a tenth or 100th of a percent. And if it's over that, it's no longer hemp. Then you're getting off into other things. You're getting off into just straight marijuana is the way it would be described. Because you got to go back and look at a Farm and Agriculture Act that come out, I'm going to say the early 2000s. And that's where all this hemp starts deviating real quick from everything. And CBD is going to be treated like that in a lot of circumstances. It's going to depend on what they find and what percentages of it. If you're under those percentages, you have hemp and you're covered and you're slick. If you are over those percentages in Mississippi, tag, you have got a controlled substance in your back pocket.
Now, Charlie also says lack of knowledge sounds like these are not my pants defense.
These are my pants.
These aren't my pants. You see that on cops a lot, you know, and these aren't my pants, you know. Patty says good explanation of own versus possess. Thank you very much. And then Rob says we love the big man. So there you go, buddy.
I appreciate it.
Yeah. So I think, yeah, this one I already essentially asked. Can I argue that the drugs belong to someone else? That was actually covered before. What is the entrapment defense?
Entrapment is essentially it's a defense that is extraordinarily hard to pull off and almost never works. So as a general rule, somebody comes and says, a cop essentially tricked me into this, that they persuaded me to do this or something along those lines. It is not going to be successful. I tell folks to run from it. I don't know of many cases in the state of Mississippi, all the research that I've done, where they said, yep, an officer entrapped you into doing this. They set it up. I know you're thinking like a drug buy or something like that, but I'm trying to think of a good way to put it. It's almost like a cop persuades you to rob a bank or something like that with the sole purpose of catching you to do that. And I'm not talking about like an undercover officer or anything like that. I'm talking about under color of law. They've done all this. Entrapment almost never comes into play. And if it does come into play, it's almost never successful. So if somebody is hanging their hat on an entrapment defense, run.
How does medical necessity work as a defense?
Well, if you've got a medical marijuana card here in the state of Mississippi, and I can't remember the exact amount that you can get marijuana. Frankly, I don't have any buddies that have a medical marijuana card, so I haven't been able to really talk to them about it, and I haven't had an issue with it. But if you have an amount that's way in excess of that, then because you're going to have a prescription, it's kind of like getting 30 hydrocodone, for example. If you've got 30 hydrocodone, a prescription bottle for that, and you really got 60 hydrocodone in there, well, 30 of them you're covered for. The other 30, you're out of luck on. So it's the same way with the medical marijuana. If you have the medical marijuana card and you can have, I don't know, let's call 5 joints the number, and you've got 10 joints in there, well, you may have a problem. There's an argument that goes both ways because you're going to say, hey, that was just left over from my prior prescription. When I go to the pharmacy, that's what they filled it for. Not my fault I missed a couple days. And the flip side, the state's going to say, look, they had a prescription that covered from this much, they got this much additional, that's what we're going after. So you're going to be in that kind of pickle. But if you're talking about within your prescription, then you're covered. You're not possessing anything illegal. Again, I go back to the hydrocodone or any kind of pills or anything like that that's covered under our controlled substance laws. If you get a love downtown Jackson, that's what you're hearing. My office is right on the street here on Capitol Street in Jackson.
Yeah, you mentioned the other day if you, well, we have a video we uploaded yesterday. In the beginning, you said I'm in the office in downtown, and if you hear any honking, yeah, it's the metropolis of Jackson, Mississippi, I think is what you said. So
that's exactly what it is. But if you've got the legal amount, which you have a prescription for, then you're going to be okay. If you start exceeding that, then you got a problem.
Is just out of curiosity, is recreational use of marijuana legal in Mississippi?
Nope.
Okay. Good. I'll remember that if I ever come to Mississippi.
Well, Steve, are you admitting to doing something?
No, actually, no. Too dang old for that crap. That was a joke.
Oh, oh, you got a sense of humor now. Okay.
Yeah, there we go. It's not a joke if you have to tell people it's a joke, though. what's the difference between actual and constructive possession?
That's what we talked about, where actual possession is I actually have my keys in my pocket. I'm actually in possession of them, as opposed to them being in a desk drawer over here in my office. They're sitting in my desk drawer. I constructively possess them. It's my office. My name is on the lease. I'm presumed to be in possession of them, but you must show something more than mere proximity for you to actually get convicted of a possession charge when you don't have it on me. So if they would take the keys I just pulled out, dust them for fingerprints, run my fingerprints, which are in every damn system you can imagine, so I could become a lawyer, then they're going to see it pop up and they'll go, well, Joey exercised dominion and control over these at some point or another, so we about to tag the big man.
Got a few comments here in the chat. Charlie, who's made quite a few comments, he's originally from your home state, or he's in your home state, Louisiana.
Ah, good deal. I think I've actually responded to something, Charlie.
Have you?
I think so.
Are you from Monroe? Is
Yeah.
that okay? I
From West
thought I
Monroe
remembered
originally.
that correctly. Yeah. So he says you got to have it in the original package, at least here in Louisiana.
I would strongly advise it. It's kind of like the pill bottle example I was saying. If you got it in the pill bottle that they handed you, if you've got it in the, I don't know if they give it to you in a bag here. I don't know if they have a box of it you get. Because like I said, I just don't have any buddies that have that. And I haven't run into anybody that's gotten tagged. Because you got to remember, our marijuana law really just kicked in technically at the end of last year, but nobody saw anything of them until this year. Yeah, you had a few dispensaries that opened up, but they weren't, you didn't have anybody that had the approved card last year, so nobody saw anything. Now you get a bunch of people with the approved card, but I haven't run across any issues where an individual has prescription marijuana that they're saying, hey, that's not compliance with your prescription. I have not run across that case yet.
Well, so Tori's asking a question. What this is timely. What if I get charged with possession and I had my medical card on me at the time?
It's the same thing. If you've got it in the prescription bottle or the prescription box or prescription bag, and it's the quantity that comports with that prescription, I think you're going to be okay. If you've got something that's way out there, again, I use the example of hydrocodone just simply because it's a pretty common charge to see somebody with pills down here. If you've got a prescription for 30, but you really got 60 in there, you've got a problem. Also, you're going to run into the issue of people admitting to taking or using these, whether it's marijuana, whether it's pills, and then you just walk right into a DUI situation.
Okay. Here's a comment from Patty. It seems that if there's going to be cannabis laws on the books, you should supply LE with the means to test it.
Well, law enforcement does
one more thing. I'm in California. It's different, but there are many regulations attached. Okay, I'm sorry. Go ahead.
Law enforcement does have some basic means of testing some things. They got the very basic field kit for cocaine and stuff like that. But that's just, again, that's going to be a probable cause test. Does it indicate yes? Okay, well, now we have more than just my skills, knowledge, education, experience, and training telling me that I think this is cocaine as opposed to baking soda. I got a scientific test that has met all the scientific methods and can be replicated and is testing positive, and it has a 97% accuracy rate. So now I really think I got cocaine on here. We're going to send it to the crime lab, and the crime lab's going to do the definitive test. So they have some of those testing abilities. Now, as far as marijuana, again, they really just rely on their skills, knowledge, education, experience, training. Yeah, marijuana, you've heard them say it's loud. They talk about the smell of it. It's loud. It almost doesn't make sense when you think of it that way, but it really pops. You go down to Rankin County, walk into their jail, anywhere down there, they got their evidence locker right before you go into the jail. And I can sit there and tell you when they've done a drug bust. You can walk by and smell it. So that's what they're using as sort of their test, the smell test. Is it 100% right? No, it's not 100%. The gummies, whenever somebody hands them the gummies, they hand it to them in the package and they flip the package over and it says THC on it. Well, that's marijuana to me. So I'm taking you in. And that's why I tell folks, don't admit to any of this stuff. Don't give them anything. They're called detectives. Let them detect. They're called investigators. Let them investigate. It ain't your job to do their job for them.
Don't snitch on yourself.
Yeah.
Yeah. And by the way, I am monitoring the chat. We're live right now at what time is it? 2:23 p.m. Central Time. And if you got a question or anything you want to say, just let me know. Rob says Attorney Franks is very knowledgeable. That's why I love this channel. Mississippi is lucky to have him. There you go, buddy.
I'll take it.
Okay. And then Charlie again, has Joey had any clients get charges dismissed because the crime lab was backed up or lost the samples?
Yes. I've had one case that sat on a docket for 2 years. Every time they had a docket call, I showed up and said, no, we moved to dismiss. The state carries a burden here. And eventually the state said, okay. The judge, not the state, said, yeah, we've gone past the reasonable amount of time. So we're pulling the plug on this.
Okay. Trying to find where I left off. I had so many chat questions. Okay. How can a possession charge be dismissed due to lack of evidence?
Again, say for example, the evidence locker in Rankin County I was talking about. If that building, God forbid, that building catches fire with this statement. If that building caught fire and burned down, and there's no evidence against you at that point. Well, they don't have anything. If the chain of custody is off, if they can't account for what happened to it over a 2-3 hour period or something like that, they got a problem. If the forensics laboratory starts to do a test on it and their machine malfunctions and it destroys it, well, there's no evidence. So you have a right as a defendant to go in and have your own independent examination done. Most people don't do it because it's cost prohibitive and it's unlikely that you're going to come back with a drastically different result unless you can see that there's some chain of custody issue. You go look at it and say, that's been tampered with a little bit. Something seems off about that. Then that would trigger, hey, let's go have an independent lab look at this. And speaking of the crime lab being backed up, I've actually seen our crime lab get so backed up on cases that they have sent stuff to independent labs themselves, the state has, just so they could get a timely result back.
Wow. Yeah. That is backed up. Okay. So what if I didn't know that the substance was illegal?
Again, you've heard the whole saying, knowledge of the stupidity, ignorance of the law, ignorance of the law is no excuse. And that's exactly what you're about to get tagged with. I have people all the time that get caught driving from Florida up through Mississippi. This happened more before we had our medical marijuana card, but they'd be driving from out of state, come through here and go, it's perfectly legal where I'm from. It's not legal here. So they're going to tag you. Now, those people actually had a interesting constitutional argument under the full faith and credit clause. So if, for example, Florida lets you have a medical marijuana card and you're passing through Mississippi and you have it, well, it's kind of like you have a Florida driver's license. Mississippi's got to acknowledge that you have a valid Florida driver's license. So it's kind of that same concept. So those people had some really interesting arguments. But I'm trying to think what's the name of it. It's perfectly legal here. It's a damn felony up in Arkansas, kratom. That's it. You can go buy kratom at any gas station here in Mississippi. It's perfectly legal. You can go buy it up in Greenville, Mississippi, and when you get to Little Rock and get pulled over, you've got a felony. So ignorance isn't going to be you're out. It's right. Either it is or it isn't, and you possessed it or you didn't.
So what is that? What's the name of it? Because I've heard the name before, but I never remember it. Kratom or something? Huh?
It's kratom. I think okay. Take that to kind of mellow out a bit.
I see. Okay.
And it's not in our controlled substances down here. So that's where folks try to slip in under everything there. And I guess as long as you stay within Mississippi's state lines, you're fine with it. But the second you cross over, I know Arkansas. I don't know about Tennessee, Alabama, or Louisiana, but you cross over into Arkansas, you're going to need to call my buddy John Collins because you're going to need a good criminal defense attorney there.
Okay. What happens if I'm a first time offender? The question is, what happens if I'm a first time offender? Can the charges be dropped? Now, if I got heroin on me, I doubt it. But let's say I just had a little bit of pot, and a little bag in my pocket. What happens there in Mississippi?
Well, it's a simple and complicated answer because even if you're talking about heroin, meth, cocaine, weed, you pick it, so long as it's not fentanyl. God's sakes, don't have fentanyl
No.
for reasons. But Mississippi has what we call our intervention courts, commonly referred to as drug courts. So a lot of times, if this is somebody's first offense and it's a low amount, now if you've got a trafficking charge, you're not going to qualify for drug court. They're not going to let you in there at all. So if you have any of those, then they're going to offer you drug court almost certainly, and that's where you go and you jump through the hoops. You're on supervised probation essentially for a period of time. You pay a monthly charge, and once you complete everything, the case is dismissed. It's like it never happened essentially. There's also something called pretrial diversion. That's less common for a drug charge. It's more common with other minor felonies, but it's possible to get pretrial diversion out of a drug charge. And that's where you go. And it's just that you go handle this before going to court. And you go jump through their hoops. You're going to pay again a monthly fee. You're going to pay any restitution. They may order you to do drug testing. And once you complete it, again, the charges against you are dismissed. And those are two of the easy outs for pleas and things like that. Now, as far as them getting dismissed, if the probable cause officer, if he moves from Mississippi to Montana to take a job up there because he likes to show Yellowstone, well, he's not coming back to Mississippi to testify against you. And if they don't have a probable cause, they don't have the rest of it. So that's a good way of getting it dismissed. And if your arresting officer on this actually the ones that grab the drugs, well, they're not there. They went to Montana to be part of the Yellowstone cult. Well, again, they're not coming. Get it dismissed. Sixth Amendment right to confront your accusers. There's so many ways to get a case dismissed that I could talk about until 5 o'clock today, and we still couldn't go over all of them every nuanced way. But those are some of the big ones that you see pop up.
Okay, so we both get a couple compliments here, Joey. I even got one. Charlie says, Steve has such a radio voice. I'm trying to place why it sounds familiar. Is it Paul Harvey that he sounds like? It's a joke on Paul Harvey. Do you remember you remember Paul Harvey, don't you?
Yeah, I know the rest of the story.
I just don't know how long hasn't been on the air. I grew up listening to him.
I think he passed away something better part of 10 years ago now.
Yeah, at least, yeah. And then Tori says, Attorney Franks, you're extremely smart, very great information from the big man.
Glad I could help.
Yeah, there we go.
Going back to Paul Harvey, I always liked Earl Pitts, who come on. I can't remember if he come on right before or after Paul Harvey when I was growing up.
Yeah, he was on any station that had an ABC network feed. And ABC had 4 different networks and radio networks. Yeah, this is the old radio guy in me. I mean, you heard him everywhere. He could be on 2 or 3 stations in a market too, which was kind of unusual, because they didn't. Yeah, if you had, there was like ABC Rock, ABC Information, ABC something else, and ABC something else. So he could be on all 4 of those stations that had those networks, individual networks, and so okay. So that was kind of unusual, I think. Yeah, and as far as the radio thing goes, I'm a legend in my own mind. I used to work in radio a long time ago. Okay. How can proving insufficient quantity help in my defense?
So in Mississippi, everything is based on the quantity. It's one dosage unit to, let's just say 10 dosage units is what you find as a common requirement. If they can't show that one dosage unit, which may be a pill, it may be, depending on what drug, it may be defined very specifically by statute. But for example, I've had somebody get caught with a vape that had THC in it allegedly, and they couldn't say how much THC in there, as in weight. Of course, I moved to dismiss because, hey, you've got to have a quantity. So quantity is very, very important in Mississippi. And if they can't quantify it, they can't tell what part of the statute, because that becomes an element of your crime. Just because you possess cocaine, for example, until they can tell you how much cocaine you have, then they can't tell what part of the statute you fall under. Are you trafficking with a pound and a half of it over here, or do you have what's that comedian rehab guy? Do you have just a little toot of cocaine over here?
Can prescription drugs lead to a drug possession charge?
Absolutely. If it's not your name on the bottle, you got a problem.
Okay. I used to travel a lot, and now a statin, blood pressure, some allergy meds, but I always carried the bottles with me just to be safe as I'm going through TSA and stuff.
They're going to look at the bottle, and I've had some clients that try putting other pills in the bottle. So,
Oh, yeah.
have I don't know, an antibiotic. You pick whatever it is, amoxicillin, for example.
Amoxicillin.
And they go put some hydrocodone tablets in there. We start looking at the tablets, and amoxicillin might be a white, chalky like pill, and the hydrocodone, it may say, is essentially a cylindrical shaped pill that doesn't meet the same shape, same color, anything. So the officer starts looking on their little database and sees these pills aren't what should be in there, and that can be probable cause to lead right on down the road.
Okay, we've got a question from Charlotte, North Carolina. Very interesting. Missed the beginning. What's your educational background? Well, you went to college and law school, but graduated from both.
Yeah, I went to ULM over in Monroe. I was a real special kid there. It took me 5 years to get my undergraduate degree. I think I liked having a little bit of too much fun, but the drugs have never been my thing. I like drinking as much as the next person, but I never got into any kind of trouble or anything like that. And from there, I actually went to work on the railroad. And I did that for about a year and a half and decided, you know what, if I'm going to go to law school, now is the time to do it. Otherwise, I'll be running the same set of tracks for the next 35 years. And I went to MC Law here in Jackson, Mississippi. I almost went to Texas Wesleyan over in Dallas, Fort Worth. And I was negotiating I had MC and Texas Wesleyan negotiating on how much they wanted to pay in scholarships. And I pulled the trigger on MC because they had the highest bar passage rate in Mississippi and the highest out of state bar passage rate in Louisiana. And originally I was going to take both bars. And in hindsight, if I'd gone to Texas Wesleyan, I would have a law degree from Texas A&M. They got bought out like my third year of law school.
Oh, wow. Oh, I'll be darned. Yeah, I'm kind of the same with you on the undergraduate degree. I worked my way through college doing nights at a radio station a long time ago, because I don't think they have live DJs doing nights at radio stations anymore. They're all voice tracked or syndicated, but it took me 6 years.
At working and going to college, you were proud to get to college classroom.
Oh man, I was so glad to get my degree.
I worked at a paper mill, and I did that one summer, and I was working evenings and nights when college started. I knew I couldn't maintain working at the paper mill and going to college at the same time, but I figured I could pull it off for that 2 weeks because I was making so much, what I thought was a boatload of money at the time. And I can remember I sat down beside this young lady in class, and she started sniffing, and she looked over at me and smelled me. And she goes, "Is that you?" I said, "Yeah, that's me." She goes, "What is that?" I said, "That's my new cologne. Do you like it?" The hell up about that? That smell like a paper mill.
That's a good one. Yeah. Okay, let's get to the next question. So we answered that question from Charlotte. Oh, do we have another one?
Yeah, that was from
Oh,
Charlotte.
hold on. Do you have an asset forfeiture? Or
Asset forfeiture.
forfeiture? Yeah. Boy, I was having a brain seizure there. Asset forfeiture in Mississippi.
Yes, we do. And some interesting case law come down on that a couple of years ago. There was a guy driving like a Land Rover, and he got busted with a joint in the ashtray, and they confiscated his $100,000 car over a joint. And Supreme Court come back and said, no, that's unreasonable. You can't do that. But you go over to what city is that? Not Raymond, Richland. They got a city vehicle that says paid for by drug dealers because they seized a truck that was used as part of a drug operation. So the where I normally hear about asset forfeiture and seizures and things like that. So asset forfeiture is if you're using it as part of the drugs, you're going to get tagged. They're going to take it. If you have money, that's the big one I run into, where say you've got $50,000 on you, and you don't have a bank receipt, and they find drugs in the car in a duffel bag. Well, they're going to take that $50,000, and if you don't go and file with the circuit court very quickly, I think it's 20 or 30 days, then you're going to lose that. You've waived your right to go argue that that's not related to drugs or to show some valid way of getting it. And that's a win big, lose big proposition. That means either you get all your money back or you don't get a damn thing back. And the problem we run into as attorneys is, as much as we like helping people, it is a business that we are running. So we still charge people for that stuff. And they say, well, I can't afford your hourly rate. Okay, well, I'll work on a percentage of it. And I've had somebody call me before and we've talked about the numbers and they said, okay, well, what would you charge to do this? And I quoted them a percentage and they said, well, this ain't my money. Even if I get it back, I'm still this percentage light. I'm like, well, I don't know what to tell you on that one, but I've worked with attorneys kind of on the side who don't normally do criminal defense. They're very good civil attorneys. And I've looked at things to see whether there was probable cause for the stop. And I've been on the fringes, but I've never actually delved off into one of them because I've never had anybody want to hire me on one
of them. Another compliment here from Pat. Thank you. Super to see this discussion. So that's kind of, yeah, I don't know. It's kind of cool. I get a big kick out of it.
Enjoying it. Pat comments a good bit, if I'm not mistaken. If it's the Pat I'm thinking about.
And by the way, if you do have a question for the big man, Attorney Joey Franks, just go ahead and put them in chat. We'll answer them. He'll answer them. Oh, here's a good question I found. Let's say I'm getting a ride somewhere. I'm not driving. I'm, in the passenger seat or the back seat. I'm just hitching a ride. And the driver gets pulled over for whatever reason. They search the car, they find drugs. Can I be charged with possession of drugs if I'm just riding in the car?
You bet.
You can.
The driver says that's my drugs. And the policeman go, well, it's one of y'all's drugs. So we'll go ahead and arrest both of you because there's a reasonable belief that this drug belongs to one of the two of you. And you're both going to get arrested. If the individual says, hey, that was my stuff, that me and you were in that same car, and I said, that's mine, they'd let you go most likely. And the flip side of it, if I said, don't have a clue about it, you turn around and say, I don't have a clue about it, well, they'd arrest both of us, and then we both get to go argue it out, and hopefully we all stuck to our story.
Okay. What is the I think you answered this before, but I'm going to ask it again because I'll be splitting this video up and making individual videos out of it. So, what is the chain of custody defense?
Chain of custody defense is you get pulled over, officer has probable cause, officer searches your car, officer finds marijuana. From there, you're usually going to see them take it and lay it on their dashboard. Not their dashboard, excuse me. It's going to be on their dash cam. It'll be on the hood of their car, and the dash cam will be looking at it. And from there, you'll see them come back with evidence bags, and they'll start writing who had what, at what time on those bags. And then they'll take it down to the evidence locker. The evidence officer will sign that he received it or she received it at this time on this day, put it in the evidence locker. And every time somebody comes and takes it out, they have to sign for it. If it goes to the crime lab, somebody's going to come down there, somebody's going to sign it out, and they got to take it to the crime lab. The crime lab person's got to account for all the times that they had it, and it's got to be accounted for all the way back till it goes back to the evidence locker, and then it's got to be accounted for all the way up until trial. And if something happens with that chain of custody, then the state's got a real problem, because we don't know what happened. Did it get swapped? Did somebody spill some of it? Did somebody add something to it? So there's a whole issue of what happened. And if the state cannot, you got to remember, the state bears all burdens here. Defendants don't bear any burdens. They are innocent until they are proven guilty. And it's the state's job to prove them guilty beyond a reasonable doubt. And unless they can show that everything has been in the state's custody, and we can show where it went, when it went, and how we are where we are now, then they've got a real problem. You've got a real argument to get your case dismissed if they don't comply with that.
Okay, so this is going to be Mississippi because the big man's licensed there and practices there. But are drug possession charges misdemeanors or felonies? Talk about that.
They're both. You
Okay.
can just a little bit of marijuana on you, a simple possession charge, you're looking at a fine of up to $250 if it's just a simple possession charge. All the way up to, if you get drug trafficking, you can potentially be looking at life in prison, depending on how much, what you got, and any kind of enhancements that may be going along with that. So you've got the real gamut of options when it comes to sentencing on that. You start getting, depending on the drugs, you start getting above 1 or 2 dosage units, the statute bumps it up to a felony. And then once you start getting above, say, 10 dosage units, you start going from 3 to 8 years to 8 to 20 years or something like that. And it just depends on which schedule you have and what quantity you have. So you can get something as simple as a slap on the wrist. You can get something that's 90 days in jail. You can get something 20 years in jail, 40 years in jail. It just depends. And when I say jail for 20 and 40 years, it's really prison. Anytime you're talking over 1 year for a single charge, that's prison. Anything less, a year or less, is jail. Think of it as the county jail. So it can be a misdemeanor that is simple. You can have it non-adjudicated. You can have it expunged later to a felony. You can do pretrial diversion and avoid it that way and get that expunged. You can do a felony that's on your record, and then after you jump through all the hoops and it's the only felony you've got, you can get that expunged and it's like it never happened. Or you can be selling drugs in a school zone with a pistol in your pants, and you're going to go to prison and you're not getting that expunged.
Explain non-adjudication, specifically how it works in Mississippi.
The way it works is you've been charged with a crime. You technically stand in front of the court and say, "Court, I am guilty of the charge presented to you, and I petition you for non-adjudication." And the judge takes your guilty plea and puts your guilty plea on the corner of his or her desk and tells you you're about to go jump through a bunch of hoops. And for a misdemeanor, let's just say in our justice or municipal courts, because those are the only courts that will handle misdemeanors, generally speaking, get up to the county court and circuit court with misdemeanors on appeal, but generally you don't start there. The judge is going to take that guilty plea, put it on the corner of his or her desk, and tell you to go jump through some hoops. You're going to pay fines. You are going to go and be under either supervised or unsupervised probation for up to 2 years. That sounds really scary. Most courts only do it for 6 months. I know one judge here locally that does it for 18 months, and that's about the highest I've come across in the state of Mississippi as far as non-adjudication on a drug charge. They can order you to pee in the cup. You can do the drug and alcohol assessment. I've seen them send people to a facility called Region 8, and that's kind of a rehab facility of sorts. And they complete all the terms of that, and then they go back to the court and they follow up for 6 months or something along those lines. And I've also seen it to where they said, "You pay your fine, you live out of state, we're never going to see you again." And me and the client have walked to the clerk's office, paid the fine. Judge signed the final order of non-adjudication the same day that the judge signed the petition for non-adjudication. and everybody walked out of there and it was a done deal. But non-adjudication means there is no final adjudication on your case. You are not found guilty. The case isn't technically dismissed. It's the court just saying, we are not going to adjudicate guilt here. And you go and you start looking in our expungement statutes, it says that anything can be expunged where there's no final disposition or no adjudication of the case. And that's how you go and get those cases expunged off people's record. The arrest and everything is going at that.
Left-handed RN asks, what rights do law enforcement have to ask passengers for their ID? You know, I asked that passenger question.
You know, IDing is a big thing. People argue about it. And I understand you have the right to, you can say no and all that, but you are picking a fight and the officer is going to find a reason to arrest you at that point. I hate the ID arguments and I love them at the same time. But if you're in the automobile, for example, and the officers pulled them over for speeding, well, they don't need your ID. You know, asking for that, can you refuse it? Sure. Are you setting yourself up to get asked to step outside the vehicle? You bet. So you're going to set something in motion that you may not want to set in motion. If you've got warrants and things like that out there, well, I mean, you're weighing your risk. Do you want to just sit in your car, argue about the ID, and take a chance that the officer arrests you for failure to comply and decides to argue it later in court, and you still get tagged on the warrants, or do you hand the ID and hope that the warrants don't pop up? So I get that. But again, if you're going back to your drug charge where one guy says, it ain't my drugs, well, the officers don't come up there and say, all right, give me your ID. He's saying it's not his drugs. So we're about to figure out who you are and whether or not this is your drugs. So do you want to go down the argument of the ID path? Generally speaking, I say no. I don't think the juice is worth the squeeze. And you don't have to give them a whole lot of information. You don't have to sit there and jabber with them, but give them the ID, let them run it, go on about your business. If you've got a clean record. If you don't have a clean record, well, you're weighing other options in your mind that I can't tell you one way or the other about. I don't know what I would do in that situation until I'd be in a situation like that.
Here's one. Charlie again, our friend Charlie. What are some of your hobbies? And I know you and I share one hobby, you know.
I love trains. I worked on the railroad. I started out as a brakeman, worked up to a conductor, and worked up to a locomotive engineer on a short line. And then I went to work for the Illinois Central and actually took a demotion back to brakeman and conductor, but they paid a hell of a lot more money. But I love trains. My grandpa was a fireman for the Missouri Pacific. You know, I love photographing trains. I like model trains. It's definitely a hobby. After that, photography, I've got some really great photography gear I've gotten over the years. And I actually all started because of the law firm on photography. I was trying to film some videos, some very early videos. If you go back to my YouTube channel, my earliest videos were filmed outside because my dumb ass went and bought a Canon Rebel. And I was being super cheap, so I bought an international model. What I did not realize is that international fluorescent lights operate on a different wavelength than US wavelengths in their fluorescent lights. So if I was filming like in this office right now, there'd be like a rolling background from the old TVs on here, and it would look terrible. And I learned all that the hard way, but I enjoy photography. And after that, I enjoy guns. I'm not a big hunter or anything like that, but I'm a member at a range here, and I probably go shoot once every week or so. And that's something I really enjoy doing. That's probably my big three hobbies. I mean, I got a dog, and I love playing with my dog. And, you know, I got that toddler. I love Jake to death. He's a great blast and everything like that. But he definitely qualifies as more than a hobby.
Yeah. Now, is he 2 yet?
Not yet. He's 19 months and some
Okay.
change right now. And he's actually out right now. Bailey had to take care of him today because it's the second time that poor kid come down with something. We took him for his 18-month visit, and the doctor said, hate to be the one to tell you this, but he's gonna have to miss out on daycare for a couple days.
Oh boy. Yeah. He gets everything that comes down the pike. Now, you got another one coming.
I have another one coming. I got a second baby boy that'll be here in January. We will have 2 under 2 for approximately 2 weeks.
Wow. Wow. I see. I can't imagine. I got 2 kids, but they're 17 years apart. So they're basically only children. But
No. This, I think that the 2 is where the planning stops. Anything after that is a unscheduled stop.
right, right, exactly. Now, don't you collect N scale locomotives? The little N scale is the smallest, right?
Well, you technically have D scale. It's the absolute smallest, but
Okay.
I got fingers, so I couldn't mess with that.
Yeah. Okay. But you collect those. I remember going to I like to go to the train shows and just look around and you said, well, if you see this and this and this
Yep.
and that and N scale, and I took a bunch of pictures of them and they weren't exclusive enough for you, because so
No,
you must have quite a few already. Yeah.
well, it's not that I have a few, it's that I know I don't have as much space as I would like, so I'm very selective on what I will go in.
Right. Right.
But you're up in Nebraska, so you have access to things that I'm not going to run across here in Jackson, Mississippi. That's all there is to it. I have to go over to Birmingham or really Atlanta or New Orleans to find some of
Well, let's get back to the questions here.
that.
What role does intent play in a possession charge?
Again, it is whether or not you had it or not. Did you intend to possess it? Did you exercise dominion or control? If you've exercised dominion or control, the intent is there. There's no way around it. I keep saying that if you find your fingerprints on it, it is hard to get around that because then your argument goes, well, I didn't know what that was, or I didn't intend to touch that. But you look at the totality of the circumstances and the deck is stacked against you. Excuse me. So I'm looking at very procedural arguments when it comes to those kind of cases. Somebody says, I didn't intend. No, I'm looking to see if I can kill it on probable cause. I want to kill something with the crime lab. I don't want to get off in the ditches arguing over the facts because that's exactly what we're going to end up doing is slogging it out through all kind of soupy mess, trying to persuade a jury or a judge if you're in the municipal or justice court. Hey, the guy didn't know about this. And when you start looking at the totality of the circumstances, those arguments become very difficult because if you look at one thing on its own, well, I didn't know about it. Okay, well, they found your fingerprints on it. Yeah, I didn't know that's what it was, though. Okay, but Joe Bob over here says that he was with you at the warehouse when y'all knew y'all were loading up the duffel bags. You see how I'm saying it?
Yeah. Yeah.
Coming together, and it's very rare that you just have this one piece of evidence that it doesn't quite make sense. That they got their fingerprints on this, but they're not on the gun. They're not on anything else in that bag. So what really happened? It's really unusual that you see that one element come across.
Is it possible, well, with the understanding that the crime labs are really backed up, but let's say all things being equal, is it possible to challenge the accuracy of the drug testing?
Sure, go challenge it all day, every day. Depending on exactly what they're doing, you don't want to know what their standard operating procedures are. Did they test it on its own, or they put it on a pallet or a tray with 49 other samples and test all 50 of them at once? And you will know what the results of all 50 of them are suddenly. And if they can't answer that, they got a problem. Another thing that you run into, for example, on testing alcohol in blood samples, the needle never actually goes into the blood to test it. They're actually injecting gases that force the alcohol to rise up, and it's measuring the gas alcohol coming off of it. Well, they're doing some of those depending on what drug it is, you run into similar tests. So you want to know whether or not they're doing these things, and you present these tests to a jury and you phrase it in a certain way, then you can really stump up especially an inexperienced crime lab person. But if you've got the supervisor or something like that, they're a lot less likely to stump up over it, but it happens.
Can a drug possession conviction be expunged?
It can, depending on what it is and how many you've had. Misdemeanors, you can get them expunged all day. Felonies, if you've gone on pretrial diversion or you've been through the drug court program, the intervention court, again, you can get that expunged, not a problem. If this is your first felony and you just had some cocaine and you didn't do drug court, and we're not talking about a brick of cocaine. We're talking about, again, I got a rehab guide, a little toot of cocaine, and you can get that expunged once you've completed everything and let any kind of required times run. I think it's 5 years on a felony, 5 years from the completion of all the terms and conditions. So once you've got everything complete, and I'll have to go back and check that. I know that's what it is on DUI first, but I always have to check those expungement statutes because they change in July when we have all our law changes happen in Mississippi. Once you start getting off into intent to distribute and trafficking, you're not getting that expunged. And also keep in mind, if they have you on a drug charge and at any point the judge wrote in there that they find it is a crime of violence, you're not getting that expunged. It's unusual that they do that, but it's a caveat I like to tell everybody about, because I hate to get hired to go do an expungement. They hand me the order later and it says, oh, by the way, we found this was a crime of violence. Well, we got a problem.
We're just about ready to wrap things up, but if you got a question for the big man, we're pretty much talking about drug possession charges. You can ask any legal question you want. With that in mind, I'm going to read another comment from Charlie. Well, Charlie's got another question. Okay, he just put that in there. Let's read his. He made a comment before that that's kind of cool. My great-grandfather was an engineer for the Ark-La-Mis Railroad. Am I saying that correctly? Arkansas, Louisiana, Mississippi Railroad. Yeah. Many decades ago. Congrats to the family. I didn't know you had another one on the way. I love researching old class 3, class 2 railroads, and seeing where they were and stuff. Nebraska's a great place to rail fan because of the Union Pacific is here, and Fremont, Nebraska used to have 7 railroads going through them. The tracks are all still there, but now it's just UP and BNSF. So that's good. But we only got one short line here in the state, maybe 2, but the second one's way out west. So we don't have a lot of short lines.
Well, Charlie, the ALM is still going. It's operated by Genesee and Wyoming. It's kind of a parent company of a bunch of short line railroads.
Okay.
So it's still going, and it's connected to the Fortis and Princeton, and it's still clicking along there because it was right outside the college. So I remember that. But talking about hobbies and drugs, I told you I like guns. Keep in mind, if you have a gun with you on any kind of drug charge, you just doubled whatever the penalty was. So if it was a $500 fine and 90 days in jail, you're looking at a $1,000 fine and 180 days in jail. So, and that doesn't matter if you have the gun tucked into your pants, doesn't matter if you have it in the console of your car. If you've got the gun there, they are going to come and double your penalties on any kind of drug charge in the state of Mississippi. It's called a firearm enhancement. So don't have a gun, don't have drugs, but don't have a gun with drugs.
Then Charlie's got a last question, and he's a paralegal. He's got to get back to his job. Have you ever known, see, I got this thing in the way here. Have you ever known of a case where someone was caught with a bunch of drugs that were actually found innocent?
Innocent? It happens. Frankly, most cases don't go in front of a jury. Most of them either get dismissed or worked out ahead of time. So you don't hear of a lot. You don't hear of the state wanting to put a case in front of a jury where they don't have it airtight. Let's do it that way. So it's really unusual that you hear of a straight acquittal on drug charges simply because you don't hear of a lot of them going to jail. Because so often now you get pulled over, there's dash cam, the officer gets out, there's body cam, and 2 other officers show up and they got dash cams and they got body cams and they record everything that you said. So many people admit to, yeah, I knew it was back there, but this is my cousin's car. And they start putting the drugs on the hood of one of the cars and you have multiple cameras looking at it. The chain of custody is followed because frankly, attorneys have gone and made these arguments and we still make them, but they also understand if they get to a jury and they can't admit into evidence the drugs because there is a chain of custody problem, their case will not succeed. So you don't hear of it going in front of a jury and getting acquittal. It's almost unheard of. really, really unusual. The cases you hear about going to trial are, you know, Rankin County right now is on court TV. You can go watch court TV. I forget the young lady's name. She killed her mama. Uh, uh, Judge Arthur is on the bench on that one. I forget the name. I want to say Miss Newman is prosecuting, and Kevin Camp is the defense attorney on it. So you see murder cases, you see assault cases, you see more of the sexual cases going to a trial than you will see on the drug cases, simply because they've got it on video all the way up. They've got the custody, they've got the crime lab, and it's all right there in front of the jury to see. So you don't see a lot of drug cases go to trial.
Well, this is fun. We've been at this for an hour.
I guess we have.
Yeah, yeah. I mean, it was great we had some people watching. We got a lot of chat questions and stuff like that. So I had a blast doing this.
It was fun, I admit. It's fun doing it in the middle of the day on a Friday too.
Yeah, yeah, it is.
A little work here.
It's a great way to end up the week, you know. Kind of puts me in a good mood. So, well, to everybody that's watching on YouTube, I think we're going to go ahead and end the live stream now. I'm not seeing any more questions or anything. So thanks. And this will be available for replay. And then thanks for tuning in.
Awesome. Appreciate it, Rob, Tori, Charlie, Pat. Anytime you have any questions, fire them away.